Good morning, ladies and gentlemen. Welcome to this third webinar in the 2021 series by specialist property practitioners at Maitland Chambers. In the next hour or so, Philomena, Tim and I are going to discuss our selected highlights from cases decided this term, which is since the more or less since the 8th of June 2021 until today. We provide no warranty that these are the only cases about which you should be aware, but we do believe they provide a reasonable cross-section of what's been going on. Although I should say that it's just been brought to my attention by Tim that there is a case today about a postman being bitten by a dog, which was a High Court action, which did have a property angle relating to the gratuitous licence granted by way of implication, by way of the presence of a letterbox. So I'm afraid we're a bit behind the curve on that case, but we won't spend much time dealing with it. The eagle-eyed and eagle-eared amongst you will notice that in a couple of instances in the next hour, we have strayed slightly outside the selected temporal and topical parameters, for which I hope you'll forgive us. We do so where it helps to refer back to some important related points arising out of other cases, albeit they have arisen in the recent past. So we're going to consider recent developments under the following heads. First of all, the subject of rectification and construction, and we're going to look at 4 cases. Monsolar dealing the substantive subject matter, which was rent review. Secondly, Britvic, which dealt with pensions, but again, we're going to look at for the purposes of rectification and rectification by construction more precisely. Thirdly, Capital Park Leeds, which was a break notice case, but a case involving questions of construction. Ralph and Ralph, a case dealing with the declaration of trust. Off the back of that, we're going to look at the recent Civil Justice Council's report on the question of compulsory ADR. Secondly, escheat, proving the old cliche about buses that you can wait for one for ages. We have 3 cases in this rather esoteric area. The first one, Pall Mall, concerning an easement of drainage, in which Tim Calland appeared for one of the defendants. Secondly, Penistone Holdings, a registration case, and thirdly, a case called Lysium Limited against Crown Estate Commissioners, which was a case involving a vesting order under Section 181 of the Law of Property Act. Thirdly, we're going to look at the 3 county court cases dealing with unopposed renewals under the 54 Act and the extent to which, if at all, the COVID emergency has had any impact upon either terms or rent. Fourthly, a raft of cases out of which we'll have to pick the bones, dealing loosely with what I've called persons unknown, which essentially are mostly protest cases, although in one case was a case concerned with antisocial disorder or behaviour. And very quickly, those are Ziegler in the Supreme Court dealing with arrests following a protest at an arms fair, Gito Estates, a protest outside a lettings agency, Lambeth and Grant, a protest on Clapham Common, which had moved from Shepherd's Bush Green, UK Gas and Oil about Surrey, the Horse Hill site in Surrey, and protests against inland drilling, City of London Corp, which was a case dealing with Epping Forest, briefly a question dealing with Urban Pioneers, an injunction obtained by Multiplex. Urban Pioneers, I think, is essentially people who have a head for heights and like to show off on Instagram, and have been a nuisance in relation to modern developments in recent times. And we reference back to 2 very recent cases in this area, or fairly recent cases in any event, Barking and Dagenham, which was the consolidated case about travel injunctions obtained by local authorities, and of course Canada Goose, a case about protests outside the Canada Goose store in, I think, Regent Street. And then if we have time after all that, we were just going to touch upon the professional negligence case in the Supreme Court, a very significant case, probably only reworking, we could discuss that, reworking the principles in relation to the analysis of a professional negligence case and the extent to which the SAMCO principles have been recast. So to that end, and in terms of the discussion, would you be good enough, if you have any questions, to put them on the chat function, and we'll do our best to answer them either during or at the end if we have time. But please be assured that we only will see the questions, so please don't be shy if you have anything that comes to mind whilst we are speaking and discussing. So with that introduction, may I pass first of all to Philomena to start the discussion in relation to construction, rectification by construction, or rectification, if that's the right way of putting it.
Yes, thank you, James. In the last couple of months, since the beginning of June, there have actually been 4 Court of Appeal cases on construction and interpretation and on rectification. And that's despite the plethora of Supreme Court authority that we have in this area. ICS, Chartbrook, Rainy Sky, Arnold and Britton, and Wood and Capita, to name but a few. And the first decision is the decision in Monsola and Woden Park, which, as James indicated, was an appeal on the proper construction of a rent review provision, and in particular, the formula by which the reviewed rent was to be calculated. The lease was actually of a solar farm, and the formula in question, or variations of it, have been quite widely used in that field, and the case itself has created a lot of interest. The appeal is interesting because it considers the principle of correction by construction and when it applies. Lord Hoffman dealt with this in 2009 in Chartbrook, and he stated it was well established that clear mistakes in drafting of documents can be corrected as a matter of construction if it's clear that a mistake has been made. That's the first point. And secondly, it's clear what the provision was meant to say. In Monsola, which admittedly was a bit of an extreme case, a 25-year lease reserved a rent of £15,000 per annum, subject to annual review with reference to changes in RPI. But due to the way the formula was unambiguously expressed, the effect of the review clause, when it was applied literally, was that each year's increase reflected not just the change in RPI for the previous year, but the cumulative change in RPI since the beginning of the lease. So the result was an exponential rise in the rent over the term, exacerbated if inflation was high in the beginning, because the increases in the early years of the term would be compounded many times over. The landlord said, well, the tenant stuck with this, it's just made a bad bargain. At first instance, Fang Court J rejected this, and on the landlord's appeal, so did the Court of Appeal. The Court of Appeal said that although the language used is important, matters are different where it's suggested that the parties have made a drafting mistake. Lord Justice Nugee, who the astute amongst you will remember was counsel in Chartbrook, held there is a distinction between a provision which seems merely imprudent or a feature of a bad bargain, and one which appears irrational. And he said the result of the literal application of the formula in the case was so bizarre as to render it clear that a drafting error had been made. To use his own words, he said it's about as plain a case of such a mistake as one could find. And to illustrate that, in year 7 of the lease term, even though the increase in RPI was at just 16.9%, in the same period, using the formula as literally applied, the rent had increased by 83.1%. Lord Justice Nugee also said that it was clear on the second Chartbrook point how the mistake should be corrected. So the rent would be adjusted each year by reference simply to the change in RPI over the preceding year alone, and not obviously compounded. So yes, Monsola is an extreme case, but those, you may ask, how can you tell when the line is crossed? It's quite difficult perhaps to know whether you're dealing with something that is bizarre or irrational rather than merely imprudent. Well, it is quite a difficult test to surmount. To illustrate something that falls on the other side of the line, the second case, which is actually a pensions case, Britvic and Britvic pensions, is quite a good example. In that case, the Court of Appeal allowed an appeal by the employer, holding that the words in issue in that case, which were "or any other rent decided by the principal employer" in the relevant provision in the scheme rules, meant any other rate, whether higher or lower, and did not mean only any higher rate. That had been what the High Court had found. So the case probably is a little different to Monsola in this respect. It's probably more a case of choosing between rival interpretations rather than a pure drafting mistake. Nevertheless, the Court of Appeal held that the existing case law, ICS, etc., provided if there was unambiguous language used in a pension deed, the court must apply it. And the court's view was that the words "any other rate" were sufficiently clear and unambiguous. So you had to construe them as meaning any rate higher or lower rather than any higher rate. If you could simply construed them as any higher rate, that would be to give the words an unnatural meaning. So that was a case that fell on the other side of the line. No corrective construction, not clear, said the Court of Appeal, that an obvious error had been made.
Is it a case, Philo, where it's a bit like an elephant? You know what it looks like, but it's a bit difficult to describe.
Exactly.
One of those sorts of legal distinctions. I mean,
exactly.
Is it the case that you've really got to have it's an unambiguously, given the context, something's gone wrong with the drafting, otherwise the court is not in a position to take the view that it's anything other than prudent and a bad bargain.
Exactly. Yeah, I think that's right.
Mm.
The third decision is Capital and Global Radio, which involved the consideration of a break provision. Now, normally, as you'll all be aware, these cases consider usually whether the tenant's done enough to comply with a break condition. The focus usually being on the proper performance of the tenant's covenants. But this case had a twist of whether the tenant, in taking too much from the property, can negate a vacant possession condition. The judge below held that it did negate the provision, and so the tenant remained on the hook for the rest of the lease. On the tenant's appeal, the Court of Appeal reversed that decision. The precondition, or the relevant precondition in the case to the exercise of the break, was that the tenant should give vacant possession of the premises to the landlord on the relevant tenant's break date. But crucially, there was not a condition on the break, as there often is, that the tenant should have complied with its covenants. So on the appeal, that forced the landlord to focus on the definition of premises. Now, this included both the original building and all fixtures and fittings whenever fixed. And what the tenant had done by the break date was to strip out 17 different items which were fixtures. Nevertheless, Lord Justice Newey held that that didn't invalidate the break. He held that the break condition of vacant possession was not concerned with the physical state of the unit, but with whether the landlord was recovering it free from what he called the conventional trilogy of people, chattels, and interests. He contrasted it with the covenant to yield up in the lease, which did require the premises to be yielded up, quotes, in a state of repair, condition, and decoration, which is consistent with the proper performance of the tenant's covenants. And he called that a telling contrast. The court also said that the landlord's interpretation would undermine business common sense, and the landlord was not without a remedy because it retained its right to claim damages for breach of covenant. So what can we take from that case? Well, for the landlord at least, in the negotiations, one needs to ensure that a tenant's break is conditional on the proper performance of the tenant's covenants. So leading now, I said there were 4 cases, to the 4th case. This is a rectification case, a case of Ralph versus Ralph, but it's a little bit unusual. It was a dispute between a father, David, and his son, Dean, about a land registry transfer form, a TR1. And the position was that David could not get a mortgage on his income alone. So he asked his son, Dean, who lived at home, to help out. But Dean didn't contribute to the purchase price, nor to the mortgage, save indirectly in the running of the house, although he did obviously have a liability under it. The interesting feature in this case was that the TR1 had been signed by the transferors, but not by the transferees. David's claim was for rectification to remove the manuscript cross from box 11 on the form, that the property would be held on trust for transferees in equal shares. It seems as if the solicitor was acting for both, just simply cross that. At first instance, the trial judge held that the declaration of joint beneficial ownership should be deleted. So David succeeded in his claim, and that was upheld on an first appeal to the High Court judge. But on the second appeal, the court allowed Dean's appeal and dismissed the claim for rectification. The Court of Appeal held that the facts as found by the trial judge meant that rectification could not be granted. The trial judge had not found a common continuing intention for the TR1 not to contain a declaration of beneficial ownership, only an absence of agreement, or indeed any discussions between the purchasers as to such ownership. But the court said that no agreement could not be equated with an agreement. It is a bit of a peculiar case because the court raised questions about whether what should have been argued before them was that the lower test for rectification that is often required where trusts are involved applied in this case. So it may not be the last word on the topic generally. However, interestingly, at the end, the court did say that the case cried out for mediation. They referred to the Civil Justice Council's report on compulsory ADR, which was only published a few days, about 10 days before the judgment was handed down. That report concludes, differing from previous views, that mandatory ADR is compatible with Article 6 of the EHRC. So some changes may be in the offing on how we deal with this. I don't know what you, Tim, and James think about that.
I was going to ask about it before we went on to mediation briefly. Am I wrong? Am I being a bit reductive about break notice cases to simply say that what they usually involve is when the notice is to be served, has it been served in time, and what does the tenant need to have done to satisfy conditions?
Yes. Yes.
I mean, is there really anything else? I mean, maybe at the edges there are going to be questions about sort of construction that you've identified, but in the mainstream break notice cases, those are the sorts of themes that we tend to see again and again, don't we?
They are.
Yeah.
They are.
Tim, is that fair, do you think, in terms of the break notice law? Yeah, well, one could describe it that. Yeah. Finally, yes, the question of compulsory mediation. I was amused looking at the report to come across a quotation from Sir Alan Ward in a case about mediation or ADR, which was taken from a case in 2013. And he said this: you may be able to drag the horse, a mule offers a better metaphor to water, but you can't force the wretched animal to drink if it stubbornly resists. I suppose you can make it run around the litigation course so vigorously that in a muck sweat, it will find the mediation trough more friendly and desirable than litigation. And I love that. I think that that's a reflection of where judges are, and it's a sort of expression of a very senior judge's then a view from the bench about how they view parties' attitudes towards mediation. And this is another one I saw in the report from Mr. Justice Norris from a boundary dispute, and all he said was parties need saving from themselves. So again, this is the judicial view of how mediation or ADR ought to work. And as you say, rightly, a working party led by Lady Justice Aspin has created this Civil Justice Council report which was released in June last month. And essentially what it does, as you say, is concludes that compulsory ADR, not just necessary mediation, but ADR may not be any longer something that the Rules Committee would not legislate for under primary legislation. And the sticking point has always been, as you'll probably remember, what Lord Dyson said in Halsey, which is that essentially compulsory ADR would contravene a litigant's Article 6.6 rights access to court.
Well, that seems to have gone now, doesn't it?
So it's gone. Exactly. I mean, Dyson himself said, I think, in a speech in about 7 years after Halsey, that essentially he'd recanted to some degree and could see that there were arguments that the Article 6, his analysis of Article 6 wasn't correct. And indeed, at the time, it was criticised. Subsequently, there's been a couple, or if not three, cases in the CJEU about the legality under Article 6 in the context of European law of compelling mediation. There was an Italian case about consumers having to mediate with their telecoms provider before they could take a case against them, and that was found by the Court of Justice to be consistent with Article 6. There was a case in 2019 called Lomax, in which the Master of the Roll said essentially that early neutral evaluation could be compelled under the provisions which already exist, CPR 3.21M, I think it is, even where one of the parties was essentially opposed to it.
Tim, I think you've had a case on early neutral evaluation recently, haven't you?
Yeah, I was in a case where we were made to have an early neutral evaluation.
Right. Yeah.
It was just a couple of weeks ago. It was a property co-ownership case in the county court where, much to the surprise of everyone, the court of its own motion and without warning, so it didn't even come out of a CMC, just told us we had to turn up to an early neutral evaluation hearing, which was a bit terrifying for everyone. Because
what was it like?
Well, I think we went into it rather skeptical because we imagined, we on my side imagined that it would be a rather sort of clumsy attempt for the judge to bash the parties' heads together and to tell them how much they're all going to lose. But actually, it was a really valuable process. Basically, we were assigned a circuit judge who we were told would not be trying the case, so that judge is effectively disqualified from dealing with the matter at trial. And she got the parties to agree what the broad issues are, and she invited us to make brief, sort of fairly high-level submissions on. There was a technical legal issue between us, and also an evaluation of the evidence that's going to have to be done at trial. But we ran through the factual issues, and then she told us what her impression of it was, and it was surprisingly useful because this is one of those cases where the parties certainly do need saving from themselves, and we'd envisaged ending up in mediation after the exchange of evidence. But actually, it was really useful because the other side, who had not thought that our legal point had any merit, heard the judge say, actually, that makes sense. And the other side, who thought that our witness wouldn't be believed, was forced to think again when the judge said, well, actually, the story makes sense, and it's hard to see who's going to be around to counter that evidence. And so after the judge giving an indication of what she thought about the issues, it then sort of ran a bit like a mediation, with the judge sending us into breakout rooms, because it was done online, to formulate offers. And we obviously we weren't compelled to formulate offers, but the thing proceeded a bit like a mediation, with the judge attempting to get the parties a bit closer to each other. And very surprisingly, we almost settled. We didn't, but it sounds like that maybe differing from a lot of mediations, that your mediator figure, the judge doing the
the ENE actually got more to grips with the legal issues than perhaps you find in mediation or standard mediations. Would that be right?
Yeah, well, I think that is right, because typically a mediator will say that they don't want to hear argument from the parties. I mean, unless it's clear there's a sticking point and the issue is going to have to be confronted. The mediator will usually say, won't they, that they want to hear about the parties' positions, not arguments.
So speaking of technical points,
yeah,
you've had a recent case on escheat, I believe. Now, in this area, I'm okay with disclaimers and vesting orders, but when I see that word, I always have to do a quick reminder of what it is. What is it? What is escheat?
Well, probably as many people in the audience will know, English land law is essentially the same feudal system of law that it was in the early Middle Ages, and escheat is one of the survivors from that system. So effectively, what escheat is everyone will know that the common perception, the sort of the man on the street's perception that the foundational interest in land is a freehold is wrong. A freehold is an estate, just like a leasehold, except that it's not limited in time and it doesn't carry obligations. But when that freehold interest terminates, one is just left with the land, and it reverts to the feudal overlord, which is the crown. So there's a number of ways that a freehold can terminate. Now they're statutory means, and so the most common one sees is a disclaimer, either by a liquidator of a company disclaiming a freehold property because it's onerous in some way, or a disclaimer by the Crown, and that typically happens where a company is dissolved, and obviously property must have an owner. So the freehold estate owned by the dissolved company will vest in the Crown as bona vacantia. What the Crown will usually do is disclaim it, as it's entitled to do under the Companies Act, so it doesn't incur any liabilities in relation to the land.
And the same is true of foreign companies, Tim, is that right as well?
Well, actually, interestingly, it's a bit different with the foreign companies, as illustrated by one of the cases here. So, the case of Lysium, Lysium and Crown Estate Commissioners, that was an application for a vesting order by a foreign company that had been dissolved and then restored to the register. And I think the points that among the points to take away from that case is that foreign companies, unlike English companies, the freehold estates owned by foreign companies, they escheat immediately upon dissolution.
There's no interim
period. They don't go
period.
to the plan as bona vacantia to decide whether to accept them or not. So it goes straight to an escheat. And the second point is the company in the Lysium case was a Gibraltar company, and Gibraltar company legislation is essentially based on the English legislation. And so just like the English legislation, the effect of being restored to the register is the company is deemed always to have existed. So that sort of retrospectively undoes any consequences of the dissolution. But what it doesn't do as regards English property is to revest the property, because the Gibraltar statute doesn't have extraterritorial effect.
It's property in England.
That's why the company ended up applying for a vesting order, as it did in that case. And so there are those two wrinkles in relation to foreign companies. And the other point that really jumps out of that case is the company, the application for a vesting order, and as people will know, a vesting order is just like a vesting order under the Insolvency Act, where property has been transferred on the dissolution of a company or on disclaimer by means of statutory transfer. A vesting order will essentially bring it back and put it into the hands of someone entitled to it.
So what's the effect of escheat? I mean, particularly in relation to derivative interests that may exist at the time that it takes place? That was something that you were considering in Pall Mall, I think.
Well, yeah, I mean that's the question at the heart of Pall Mall was whether, if you've got a freehold estate that has an easement attached to it,
yeah,
whether the easement remains attached to the land after escheat. And the context in which it arose was a claim for injunction and damages. Still is. It's ongoing because the decision was on a preliminary issue, and the claimant is the party claiming to be entitled to a prescriptive easement. And the period of prescription arose during the ownership of a previous owner, a company that ended up being dissolved, and the claimant acquired its title to the freehold by means of a grant of a fresh freehold estate from the Crown following an escheat. So old freehold disappears, land goes to Crown, Crown grants a new freehold estate to the claimant. And the question was whether any prescriptive easement that might have arisen would follow the land, or whether the land was washed clear of the easement. Anyway, the judge on the preliminary issue held that the easement went with the land, and essentially the question, which one might expect to be one of sort of deep level doctrine, was whether a pertinent interests like easements, whether they appertain to the freehold estate or whether they appertain to the land itself.
Land, yeah.
And the rather prosaic answer is given by the Law of Property Act, where there's a section that explicitly says easements attached to the land. And so it was merely a question of whether the land there meant the land you can walk on, or whether it meant the freehold estate. And the answer was the land.
Yeah, section 187, I think that is.
Yeah,
from memory.
So the position with appurtenances is the same as with derivative interests. So what you can see here is the courts, by their decisions, have effectively shorn escheat of any real surprising consequences. So when the freehold estate escheats, the land remains subject to derivative interests and to and keeps its appurtenances. And just to finish on escheat really quickly, because I know that time marches on. The other case that we have found in relation to escheat, one of the interesting things in that is it concerned an equitable interest in land that in a freehold estate that had escheated, and the Court of Appeal was willing to assume, but without that much enthusiasm, I think, that the equitable interest in the land would survive the escheat. And so that was a
non-registered transfer in that case, wasn't it?
Absolutely.
Essentially, yeah, the transferee didn't want to register it because
it was contaminated.
That's right, and there was a reputational issue that the owner was concerned about. The ultimate owner was concerned about. Yeah, that's right.
Yeah. And it ended up as a competition between the party who took a new freehold estate from the Crown and the party who had taken a transfer before the escheat but hadn't registered it. So in the end, it was a fairly standard actual occupation overriding interest case that we all learn about at law school. But I think the interesting point to take from it is there may be a question in the future about whether equitable interests follow the land in the same way that other derivative interests do. But there it is.
Yeah. So from sublime to I think the sublime, there are a number of cases that I identified earlier at the beginning and to deal with protesters. And I don't know how many of these cases have come across your desks, but I've had 3 in the last 12 months, all to do with protesters trying to prevent the felling of trees in the context of developments which have been carried out by JVs between local authorities and developers. So it's an area which I've spent quite a lot of time looking at in the last 12 months, if not longer before that. As I identified at the beginning, there are quite a few cases that have, even in this last term, have considered the question of the law that relates to the question of protest actions or claims against persons unknown, even if they're not protest actions. And it strikes me there are some common themes that flow out of those cases, rather than describing the facts of each one, which would take forever. It seems to me there are some common themes that come out of this in the context of certainly what I came across in the cases that I did in relation to trees in Hackney and Wandsworth. The first is what the appropriate court is. It strikes me that the High Court, notwithstanding the provisions of the practice direction and the rules, is really quite happy in these large-scale actions to take these cases, and they triage them through the masters, and the masters then list a hearing and pretty quickly shovel them upstairs to the judges, and that system seems to be working pretty well. So a large-scale protest, you're quite happy to, you can file your certificate and you'll get a High Court judge within a pretty quick period of time, given the urgency that's implied by the rules. Secondly, in these cases, are you seeking simply possession, or are you seeking possession and injunction? If you're seeking possession, like happened in the Clapham Common case, where there are simply protesters located in parts of, or various parts of Clapham Common, protesters that had already, as I said, and I say protesters loosely because there's a question about what actually constitutes protest. The love down people, I don't think were necessarily protesting anything particularly hard, but it was essentially a lockdown issue. Secondly, where you know the names of people, you've got to identify whether or not you need to follow the CPR Rule 6, because you can't rely upon CPR Part 55, which is against persons unknown. So you may need to obtain a substituted an order for service by an alternative method. The third question that is interesting in the context of possession claims: what is the necessary and permissible geographic extent of a possession order? So there are two cases: a Supreme Court case called Meyer, and a Supreme Court and a Court of Appeal case called Jamal. And the question was whether or not it's right that you can obtain possession order over vast different swathes of land that may be in the ownership of the same landowner, but are not in any way connected to one another. And essentially, a contiguous area, in my experience, is going to be satisfactory to a judge, particularly in a development case where you've got, for instance, the canopy of a tree. That's going to be permissible in the context of the Meyer-Jamal issue. Injunctions, service is more difficult. You've got to follow CPR 6. You've got the problems of substituted service in any event, because you can't rely upon Part 55. You've got to identify the defendants. There are two categories of defendants that were identified by Lord Sumption in a case called Cameron. Firstly, there are anonymous defendants who are identifiable but whose names you don't know, and that's perfectly permissible as a person unknown. And the secondly are anonymous and cannot be identified. And in that case, that was a claim brought in relation to a traffic case where the driver had essentially driven off, and the question was whether or not an order could be made under the Road Traffic Act against an unknown defendant. And the difficult answer to that is the court takes jurisdiction over people ultimately that it knows the identity of, or can be taken to know the identity of. And that was a problem that arose in the Epping Forest case, the Corporation of London case, where the court wasn't satisfied that you could identify everybody that would be subject matter to the final injunction that was being sought in that case, after the original claim based upon Section 222 of the Local Government Act was abandoned. Thirdly, are you applying for an interim or a final injunction? And this seems to me to be one of the really difficult areas. An interim injunction, essentially you're applying, or often applying, quia timet to restrain the apprehended threat of some sort of behaviour on the part of people who at that point may not be very well, may not be known, and they may still be anonymous. And that's permissible by reference to a case called Gamble. So in an interim sense, you're okay if you make an application by reference to American cyanamide, as was done in the Gitu Estates, and the judge in that case went through the various elements of American cyanamide, saying the stronger case for unlawful conduct, the stronger the case was on the balance of convenience. But then there arises whether or not there's an abuse that comes out of applying for an interim injunction for a long period of time. And this strikes me as something that parties may have been using to bypass what ultimately the court has said is the impermissible taking jurisdiction over people who can't identify. Because an interim injunction, I said, it's okay to say people who are by conduct become defendants because they climb a building as it was in multiplex or anything of that sort. But parties, I think, have come to the view that in order to bypass the problem I'm going to identify in a minute, you just apply for an interim injunction and you make it last for 2 years. And in the Dagenham case, which was the Travellers case, essentially that was said to be an impermissible use of the interim injunction jurisdiction, because the point of interim injunctions is simply to maintain the status quo, not in this instance to obtain effectively a final injunction by the back door, thereby bypassing the principle which I'm going to identify now in relation to final injunctions, which is this, that a final injunction only operates as between the parties to the proceedings, save in one, I think only one exceptional category, which is the case of contra mundum injunctions, which an injunction against the whole world essentially. And those sorts of injunctions tend to be granted in cases where there is a threat to life. So the Venables case involving the killers of Jamie Bulger, and more recently in June, a case called Winch, which involved the protection of the identity of a supergrass. So those sorts of cases qualify for what's called contra mundum relief. But other than that, a final injunction's got to identify, the court's got to be satisfied it's taking jurisdiction over known people. And that, I think, is going to be a problem for obtaining a final injunction against people who essentially can only be identified by reference to conduct. As I say, Spider-Man climbing up the outside of a tower in 9 Elms. The Dagenham case, which I identified on the slide, does provide quite a helpful checklist for dealing with these sorts of cases, not just in the context of local authority claims against travellers. And that's quite a good starting point for trying to wrestle with the issue I think is going to arise here. Fifthly, the temporal and geographical limits of an injunction order are quite difficult as well. And the court it's astute to limit those, even on a final basis, to what is ultimately only required in order to restrain the identified defendants and the identified behaviour. And the last area, which is the substantive area, which I don't think has been recast terribly much, but I think it's importantly examined by the Supreme Court, is this question of the balancing act between the Article 10 and 11 rights of cases where there are protests and the rights of others, be they A1P1 rights in relation to property or anything else. And Ziegler very carefully goes through the jurisprudence on this. Ziegler was a slightly different case, and the only one I know of in which essentially the decision in favour of the protesters at in the magistrates' court, because this is a criminal case, was upheld. And it may be a bit different because it was a case to do with lawful excuse under Section 137 of the Highways Act. But nonetheless, it sets out in very helpful terms what sort of things one looks at in relation to Articles 10 and 11, essentially on the necessary in a democratic society to restrain the sort of behaviour that is sought to be restrained. And those issues are set out in the judgment in Samid by the Court of Appeal, where the sort of balancing act gets very granular. So the extent of the occupation, the duration of it, the issues and how important they are to the protesters, what the location is. And in the Clapham Common case, the judge went into the circumstances of those inverted commas protests, length of time, was the Clapham Common, of any particular significance to those parties? And then on the other side, the interference with the use of the common. And of course, in relation to parks and commons, there are bylaws which are passed by local authorities under the Public Spaces Act, which regulate what people are able to do. And those parks are there as a public amenity. So the judge in that case, Mr. Justice Chamberlain, was impressed by the idea that, of course, although there was only, I think there were 30 tents in the end, people essentially on the common, local residents were unable to use that part of the common that was occupied. So that balancing exercise is now become one is identifiably a fact dependent one. But as I said, the takeaway I see from these recent Rafter cases is this tension between how one deals with identifying defendants, the use of interim injunctions, and how one, if it's now right to having to go to a final injunction, how one pulls in the necessary defendants. And you might have to do that by reference to social media. I mean, those that are identifiably protesters on Facebook, or by body cameras, by security guards, people who are looking after or protecting the site. Short of that kind of evidence, it may very well be difficult for a court to take jurisdiction over what otherwise were people who are entirely anonymous. But I think we are in for a lot more of these cases, given where we currently are in the world generally in relation to issues.
Is it right though, James, that these cases often have a transitory feature? So you get your interim injunction, and you've referred to the differences obviously between that and a final injunction. The interim injunction often does the trick, doesn't it?
Yeah, that's right. I mean,
and so you don't need to go to a final injunction because the threat's passed. Yeah,
I mean, the issue may well be the timing, because it's just simply not, on any view, seems to be permissible to obtain an interim injunction for 2 years. So that just comes to pass as a matter of default. The question is whether or not the court is going to say, I'll give an interim injunction for 3 days, 4 days. And if you're dealing with protesters that have been there before, and a lot of them have done, that is then their opportunity to come and make the argument about whether or not, even on behalf of other people, that there is the formulation injunction is the correct one. So of course, somebody who makes representations has to identify themselves. But there will be people who know about this, and there are a number of course, lawyers and barristers who appear regularly in these sorts of cases who will know exactly how to put this, so that it isn't necessarily, although you're right, it may deal with the problem. If people are astute to this, it may not.
Okay, well, we're getting a bit behind time. So I'm on the next topic of the 54 Act pandemic cases. I'm going to take this quite quickly. There have been 3 county court decisions. There's Francis and Cavendish number 2. So after the tenant's victory in the Supreme Court on ground F, the case returned to the county court to fix the terms of the new tenancy and was heard by His Honour Judge Parfitt. And the tenant had been paying a combined rent of £220,000 per annum. The judge fixed the new rent of £102,000 per annum, quite a drop, but there are some explanations for this, obviously. The original rent was largely due to a disregard on rent review of the depressing effect of alienation and user covenants. And that obviously didn't apply to the rent the process that the court was doing in fixing the rent of the new tenancy. To get to that figure of 102,000, there were, I think, 8 adjustments to reflect the depressing effect of the user covenant and the alienation provisions, but other factors as well. So, I mean, that just shows that obviously what the court is doing in fixing the rent under the new tenancy is reflecting the characteristics of the property and the terms of the proposed lease. So COVID, although it did come into, it was relevant because the experts were considering it in coming to their conclusions on the Zone A rate. It didn't feature in that case nearly as much as it did in the other 2 cases, where it was pretty much front and centre. The first in time was W.H. Smith and Commerce case, heard by His Honour Judge Richard Parkes. W.H. Smith's unit in Westfield in Shepherd's Bush was still open, or had to be open, at the time that the court was hearing the application for a new tenancy, because it contained a post office, which was essential. But all around it, non-essential units, or retail units, were all closed. So although it wasn't required to close, its sales were down by over 90%. One of the important features of the case was that there was argument over the trigger for a pandemic rent suspension clause. Now, you have to remember that by the start of the trial, the parties agreed that there should be a clause, so there wasn't a spat over that. But they were differing over the triggers. The landlord said the trigger should be when the tenant was compelled to cease trading. Well, Yeah, I mean, that wasn't unlikely to happen on the facts. And the tenant said, which was consistent with the actual position, that it should be triggered when the non-essential retail was required to close. And the court agreed with the tenant, and the landlord's proposal was effectively an empty one. The parties were way apart on the rent, but the court didn't find that surprising because of the lack of confidence in the sector. They disagreed over the treatment of the first 3 months rent-free fit-out, but the judge came down on the tenant's side on that, and it had to be devalued along with the other incentives. And then the parties' experts had agreed there should be a 20% discount to allow for the impact of the pandemic on the rental market. But the landlord was arguing that because of the presence of the pandemic clause, the rent should be uplifted by 10%. Well, the court had none of that and said that the COVID discount and the pandemic clause were not providing for the same thing. Interestingly, it also said a pandemic clause has become something that all tenants now expect, and the market has priced it in, which leads me swiftly to the last case, Poundland and Topland. It's a decision of a district judge, but here, crucially, the parties were arguing over whether there should be a pandemic clause. The tenant wanted one, and it would have had an effect of reducing the rent and service charge by 50%. But the district judge rejected this following O'May and City of London. And his reasons were that it wouldn't be fair and reasonable to impose one on the landlord because that would involve a sharing of risk in circumstances over which the landlord would have no control. Whereas without one, the tenant may have some control in the shape of reliefs or schemes that might be available to them. So with that those few swift words on the 54 Act, Tim, you need to tell us about the important Supreme Court case on duty.
Yeah, absolutely. Obviously many of you as property lawyers will get involved in professional negligence, particularly in relation to conveyancing that's gone wrong. And as you'll know, this often throws up difficult questions of identifying what the claimant is entitled to claim for. And a typical shape of problem might be that the conveyancer fails to identify some encumbrance on the title. The purchaser goes and buys the property thinking that it's unencumbered, and then subsequently discovers the encumbrance and sues the solicitor. By this time, the value of the property might have decreased substantially because of a drop in the property market. And the claimant effectively says, well, had I known it was an encumbered as opposed to an unencumbered property, I'd have never bought it. And so I would never have made this loss as the property market dropped. And the question then is the conveyancer liable just for the consequences of the encumbrance, or are they liable for the whole of the claimant's loss? And it's been clear for many years that the answer to that is that the conveyancer is only liable for the loss arising out of the encumbrance. But what has been unclear is what principle should be applied by the court in testing individual heads of claim and which side of the line they fall. And all of the difficulty arises out of a case called Samco, South Australia Asset Management Company, that was in the House of Lords back in 98, was it?
Something like that. Late
90s. The most important judgment was given by Lord Hoffman, and the problem is really created by his amazing brain. I think that he's so good at expressing complex thoughts really concisely and utterly compellingly that his judgment in this case makes so much sense, and yet it's difficult to work out exactly why. And the courts have been wrestling with what exactly the principle is ever since. And the Manchester Building Society and Grant Thornton case in the Supreme Court is important because it tells us the answers to that question: how should one approach this issue that gets called the scope of duty issue. I probably haven't got time to go into any detail about the case itself. It was a negligence claim against accountants for accounting advice given, but the principles are exactly the same for any professional. Basically, the upshot of the decision is that we no longer need to go through a convoluted exercise of applying Lord Hoffman's explanation of the principle in Samco and trying to convert it into a series of tests, counterfactual tests about what would have happened if the advice had been correct, and asking really unanswerable questions like whether the advice given by a professional is advice or information, and those kind of things. We're now given a simple checklist to work through for identifying whether, first of all, there's a claim and what loss falls within the claim. I urge you, all of you, if you have a professional negligence case, to take 20 minutes, half an hour, and read this, because it is essential reading and will be the case that everyone refers to for the next 20 years.
I'm a bit disappointed about advice and information, because I always found that quite an easy distinction to apply. It may be that one needs to. Yeah. Well, did you? Right. Well, that's interesting. I mean, I like that. You know, the general point being that most conveyancers in the context you're identifying, or even deed advisors in the sort of transactions that we come across, are not there to provide advice about the commercial advisability of the transaction. It's just about elements of it. And the information cases, which are mostly the conveyancing cases, I think are quite neatly explained by that advice information dichotomy. But I guess, given what you just said, we're not allowed to use that any longer. We're going to have to look at this scope of duty analysis by reference to Manchester. Yeah.
I think what I found difficult about the advice information distinction is it's all a matter of characterization, which is effectively what the Supreme Court says is the problem. And so you can characterize a conveyancer who says yes, who produces a certificate of title saying yes, there's no encumbrances. You can characterize that as information, but also it's the green light that the client's looking for to proceed with the transaction, and the client is often unsophisticated in property law matters, like most of the world, and really is relying on the conveyancer to say yes or no, and to say, look, I wouldn't touch this property with a barge pole, or proceed at your own risk, something like that. Which,
I mean, it's retainer letters may become much more important, because I think certainly in the cases I come across, they're not often very well drafted. But now, if you're talking about purpose, if you spell it out, then it's difficult to see how there can be an argument about it.
Yeah, I suspect this is going to focus minds on things like retainer letters. Yeah, but I don't think it'll necessarily that would lead to a big change in the landscape, because at the end of the day, people are always going to use conveyancers to do the conveyancer's task. Yeah, and they're always going to need advice on encumbrances and on things like that. And a good conveyancer will understand the client's objectives and will be able to direct their attention to the legal matters that are relevant to their decision making as understood by.
That was going to be my question, Tim. In a conveyancing context, it's less likely that there's going to be a significant change caused by the MBS case, don't you think? As opposed to a complex transaction of the in the accountancy setting, in that case, where the advisor, or the professional rather, is much more aware of the client's objectives and purpose. So it's much more at risk under the fifth question on the scope than in a conveyancing situation. Do you think that's right?
I think it all depends on the individual case, to be honest. I think what is a lot, it makes a lot clearer what questions should be asked and answered. Hopefully it will simplify the litigation of professional negligence claims, because if you've ever done claimant work, you will know that your first letter you get back from the insurers denies everything, and usually has a section on Samco saying, your quite obviously direct losses
obviously have to be redrafted.
And there's often a lot of messing around with different ways of just arguing about the scope of duty, whereas this gives a clear test that means that courts don't need to get into awkward metaphysical analyses of counterfactual worlds and that sort of thing, and it's just simply a question of what was this person here to do, what risk were they protecting the client against, and have they suffered a loss because that risk fell in.
Well,
that's the approach.
Tim, I'm sorry to say that our hour is up. Thank you both very much indeed for giving us all your thoughts on these recent issues. To our audience, thank you very much indeed for sticking with us a bit over time. I hope that you'll all manage to have some break over the summer, wherever that might be. And I invite you to check back in with our LinkedIn or website to find the date of our next webinar, which I think will probably be in September or perhaps in October. But with that, I wish you all well and goodbye.